One of the things that comes up a lot when people try to file their own applications with the US Patent and Trademark Office in particular is TEAS plus filing requirements versus TEAS standard filing requirements. And this is pretty technical information, but it's also quite important because it affects not only the cost of the application in terms of the government filing fees, but the filing requirements and the way that the application may be handled as it moves forward. So a TEAS Plus application has a lowered filing fee, currently $225 per class. But in exchange for the government giving you a lower filing fee, you have to meet certain requirements upfront and throughout the application process. And there's a penalty if those requirements are not met. Now, there's a variety of technical requirements that must be met when the application is submitted, but the most important one by far is the limitation when using TEAS Plus forms, the limitation in describing the goods and services. When you file TEAS Plus, you can only select from the pre-approved list of descriptions of goods and services that the USPTO publishes. Now, there are many great descriptions and useful things on there, but it has significant limitations, particularly in many industries that are nuanced or complicated to describe. So I generally avoid TEAS Plus applications and favor TEAS standard applications. A TEAS standard application has a filing fee today of $275 per class. So it's $50 more per class to the USPTO. But if you file TEAS standard, you never have to worry about the penalty of failing to meet the requirements. If you file TEAS Plus and you don't meet the requirements at some point along the way, you're penalized $125. So the penalty is far greater than the difference in the two filing fees. So because of the limitation in the description of goods and services, and the description of goods and services is a really, really important part of the application and can be very important in dealing with likelihood of confusion arguments and differentiating one mark from another mark. So because of the limitations and because the penalty is so much more than the difference is at the outset, I don't like the risks and limitations of using TEAS Plus. That's my personal style. Others may have other styles. I welcome their comments. Maybe one day, if you have an alternate preference and you only use TEAS Plus, tweet at me. Maybe we should have an online podcast debate as to the pros and cons of TEAS Plus versus TEAS standard. I mean, I'm half kidding, but I'm half serious because trademark application is much more of an art form than a science. There is not necessarily one right way or one wrong way to go about it. There's a lot of nuance and a lot of complexity, and that's why people are best served, applicants are best served, business owners are best served when they use experienced trademark attorneys, not only like myself, there are many others out there, when they use experienced trademark attorneys to handle these things for them. Finally, I want to note there's much more detail about the entire application process, USPTO forms, filing fees, building bold brands, why it's so important to file your trademark with the USPTO in the first place. Much more information about those things in my book, Building a Bold Brand. You can find it on my website at ericpelton.com or at the unique website, buildingaboldbrand.com, or you can find it on Amazon. And if you've read it and you enjoy it, I would love if you, number one, just let me know. Number two, leave a review on Amazon so I can help other people find the useful information that's in the book. It's actually currently listed on Kindle for the lowest price they allow. I think it's $2.99 for over 100 pages of valuable trademark content. What a bargain. Have a great day.